All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, and you shall be heard. God save the United States, great state of Florida, this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is the state of Florida versus Garcia. Counsel?
Mr. Chief Justice, good morning, and may it please the court. Assad Ali, Assistant Attorney General, on behalf of petitioner, the state of Florida. The third district erred in determining...
Could you speak up just a little bit? I don't know if the marshal could do something to adjust the volume here. It's not really working very well.
Yes, Your Honor.
That's better.
Your Honor, the third district erred in determining that respondents' convictions for second-degree murder and second-degree grand theft were legally insufficient and reversing the jury's verdict. The evidence adduced in support of both convictions was sufficient under the older discontinued circumstantial evidence standard, and importantly, under the current competent substantial evidence standard that is applicable to all criminal cases and for which Garcia's convictions must now be reviewed under. As far as the homicide conviction, the state's circumstantial evidence, when viewed in totality, was sufficient to establish each of the elements. The concern the third district had on appeal in reversing the jury's verdict and reversing that homicide conviction was this impermissible stacking of inferences. I'd like to make 2 points as to that principle. One, I think in this case, the circumstantial evidence didn't amount to what's been called the stacking of inferences. We have a collection of a variety of circumstantial evidence that are related. But
let me ask you about one aspect of the evidence. Doesn't the evidence show that Mr. Garcia lied in his description of what he did and didn't do in certain respects?
Correct, Your Honor.
Now, in our case law, isn't the circumstance that an accused has lied about what went on and what did not go on frequently used as a basis for discrediting the accused overall version of what transpired?
That's correct, Judge.
Okay.
We have that in this case, and we don't view each of these circumstantial evidence pieces in a vacuum. We don't view them in isolation. So not only do we have the inconsistent statements, we have cell phone pings, we have DNA evidence that was recovered from the victim's car after it had been thoroughly cleaned. We have the financial transactions that he obtained from the victim immediately after her disappearance. We have the nature of those transactions, the irregular circumstances in which they occurred, obtaining money through a check, obtaining money through an ATM withdrawal, obtaining money through a online transfer, all on the day after she disappeared. So combining these inferences, the circumstantial evidence does not amount to inference stacking. It's putting pieces of a puzzle together. I think in light of this court's decision in Bush v. State, I think this court made clear that circumstantial evidence should not be treated as a sort of second-class category of evidence that, it's just as relevant, it's just as reliable in so many respects as direct evidence. And I think what really animated the third's decision below was this prohibition, what some district courts have said, amounts to inference stacking or bootstrapping or pyramiding of inferences. I think in light of the Bush decision, I know this court has previously said that pyramid stacking is inextricably intertwined, with this circumstantial evidence test that's now defunct. I think that in light of the Bush decision, the impermissible inference stacking does not survive. I think one of the chief concerns of the circumstantial evidence standard of review was to prevent convictions based on mere speculation. And I know that this court said that standard jury instruction, which compels a jury to only convict if they find the state's proved its met its burden of proving beyond a reasonable doubt, protects against that. In the same respect, the jury instruction, the requirement that a jury could only convict someone of an offense if the state had met its burden, also protects against obtaining a conviction based on mere suspicion.
Counsel, could I hear the state's position? Argument that to the extent that we have doubts about the strength of a particular piece of circumstantial evidence, that our doubt goes to weight as opposed to admissibility, and that the federal rules of evidence, by contrast, have long sort of had this settled distinction between the weight you give a piece of evidence, whether it's circumstantial or not, being completely bifurcated from whether it is direct or circumstantial.
I think as far as when a reviewing court, and particularly in this jurisdiction, when it views the circumstantial evidence, it doesn't view it in isolation. I also think it's not the role of a reviewing court when making determinations of sufficiency of evidence to get into weighing the evidence. I think this court asks whether the evidence was sufficient. Could a reasonable trier of fact find all the elements of the offense beyond a reasonable doubt? And I think we maintain the perspective of viewing all reasonable inferences in favor of sustaining the jury's verdict.
Thank you.
When the state sought review in this case, Bush had not been decided, correct?
That's correct, Judge.
And so the argument, and actually when the jurisdictional briefing was completed, Bush had not been cited, correct?
Yes, Justice.
So the argument for jurisdiction was that the opinion below was inconsistent with our precedent under the old circumstantial evidence standard. Is that correct?
Yes, Your Honor.
Can you explain the basis for jurisdiction under that standard again? Well, actually, my question is more, it's clear that once Bush came out, that the opinion below is in conflict with Bush because they applied a different standard. Would it be appropriate to consider that as a basis for jurisdiction if I personally have questions about jurisdiction as it was argued originally in the briefing?
Justice Lawson, I think it would be appropriate to consider the Bush's decision in light of jurisdiction. The reason being is this case is pending direct review, all for the duration of the time that Bush was pending it. There was never in a stage of being final, so the fact that it was pending direct review, I think, another conflict jurisdiction issue arose in light of the Bush decision. We did initially petition for review based on the misapplication doctrine that the third DCA's decision misapplied this court's precedent interpreting the circumstantial evidence standard of review. But the fact that the decision has been pending for the duration of the time and Bush was issued, it's a pipeline case in that sense, and I think that another basis for a conflict jurisdiction arose in light of that Bush decision.
Thank you.
The guard against impermissible inference sacking is inextricably intertwined with the circumstantial evidence test, and I think in light of the Bush decision that abandoned that standard of review, I think that the prohibition against inference sacking also has to go. That's it didn't occur in this case, and assuming it did, I don't think it's no longer valid in light of this court's decision in Bush v. State. And if there are no further questions, I'll reserve the rest of my time for rebuttal. Thank you.
My counsel correctly notes that you can never convict on mere speculations.
Counsel, I'm
And
sorry, I'm having trouble.
I'm sorry.
I'm
Is
having
this,
trouble hearing.
is this better?
Yes, and
Thank you.
It may be my hearing, my deficient hearing.
I'm with you.
Okay.
Your Honors, the state doesn't have to exclude every reasonable hypothesis of innocence under Bush. We know that. But the state still has to present, and they always have to present, competent, substantial evidence for a jury to rationally conclude beyond a reasonable doubt that the defendant is guilty of the crimes the defendant is charged with. And however way you look at this case, from whatever direction, when you examine the sufficiency of the evidence, which is still available to do under Bush, in the light most favorable to the state, all you had is you had to guess at what happened to Larissa.
Well,
let
me walk through that with you, maybe according to the elements. So the first element is the victim is dead. And under Crane, I don't think you've ever argued that there wasn't sufficient evidence, circumstantial evidence, to show that she was dead under Crane in the test that we used. Is that correct?
Well, we certainly believe that the evidence, we don't concede that they proved she is dead. The third district said her apparent death based on the length of time of her disappearance.
So, under Crane, when no body is recovered, to survive a JOA, the state must present evidence of an abrupt and sudden change of the victim's behavior, habits, and plans. And I would add that it's just, I mean, it's every case is different, but that is so out of the ordinary given those habits that you can conclude based on that alone that the victim is dead. Is that correct? That is the law in Florida.
That is the law in Florida. And in this, I'm sorry, I didn't mean to interrupt.
And she had calling her family regularly, routines. She'd never done anything close to like this, and she just essentially disappeared.
And the jury, and the state, the third district said, and in this court.
Well, but I'm asking you, what is your argument that is not sufficient to allow a jury to come back?
That element,
with a verdict?
the evidence in that case, certainly there was countervailing, and there was for and against that element. They met the minimum threshold.
Okay.
And to demonstrate her apparent death. But and I'm going to summarize just for simplicity's sake, for argument. The last two elements really can be summarized as: did Mr. Garcia, is he responsible for her death? And this is
is that correct?
This is the nub of this case,
right,
and
okay.
I think we all agree. And it's that: is there sufficient competent evidence from which a jury could rationally conclude, beyond a reasonable doubt, that her apparent death was at the criminal agency of Mr. Garcia?
Would you agree that literally everything points to him? The DNA in the car, the fact it was scrubbed down, the fact that he ended up with all of her money by check, the cell phone information, he was with her cell phone. I mean, the video of him in the car at the ATM where he was withdrawing her funds after lying and saying he never drove her car. I mean, all of those circumstances, every piece of evidence points to him and him alone, correct?
I disagree respectfully, Your Honor.
Okay. Explain why.
They had a murder for money theory. Mm-hmm. That was their entire case, murder for money. And their own.
I mean, just to pause there and reflect that it was their entire case because he took all of her money, and we know that he did it. He ended up with all of her money, and we know he did it.
Their own evidence disproved their murder for money.
Okay.
Miss Butler, the FDLE examiner, said she probably wrote the two checks. The two checks dated, one was June 5th, one was June 10th. There was no evidence as to those online transactions, online transfers, as the third pointed out. So the state didn't prove a theft. That was the.
Well, let me just pause there. Would you agree that the evidence suggested that she signed those checks and that they were cashed by Mr. Garcia at a time when a juror could reasonably have presumed that she was dead?
Well,
we just dealt with that first element.
We disagree because the only evidence that they say that the way this happened was that on June 4th, He killed her at his house and disposed of the body in her car. Okay, they say that because on June 4th, her old phone starts to, the usage changes. They don't account for her new phone. They say that the house, the car, but all of the evidence, and they tried to prove that, but they didn't. And you only need to look at the forensic testimony in this case to see that every time they tested the car, it came out negative for blood. Detective Segovia, 3 months before trial, retested the car. He tore it apart. He had them go through the cushions because they thought, well, maybe the car was so clean that the evidence of blood, but they can't do that in the cushions. Came up nothing. Cadaver dog at the car, at his apartment, nothing. So every theory they posited as to how this
Now,
happened
just with respect,
fell apart on their own evidence.
Well, with respect to the blood, someone had thoroughly cleaned the car with bleach, correct?
Well, the testimony, that isn't, that's
okay,
not,
correct me if I'm wrong. Yeah.
The testimony was that when the car was returned on June 10th, and when it was opened up on June 18th, it smelled like it had been cleaned. Well, no, it's sitting out in the summer sun in Miami, so however that is. But, the jury is certainly entitled to infer that the car had been cleaned, and who cleaned it, we don't know. When it was cleaned, we don't know. He was in possession of the car. They could have.
We do know that he was filmed
on June 5th,
driving the car.
On June 5th, he's seen in the car. So no question. But you don't have the. But I'm
let's
sorry.
just look at the car, for example. I mean, if not him, who else? Using the old standard, what's the reasonable hypothesis that it was anybody other than him?
The reasonable hypothesis is that the evidence shows that their theory that he killed her to steal her money is not true because she wrote $40,000 worth of checks to him.
Well, but counsel, aren't you overlooking? I understand we have the expert testimony about the signatures. We also have this evidence that, if I recall correctly, was found in the defendant's home of someone having repetitively traced the signature of the victim and left an impression on paper from repetitively tracing a signature. Couldn't a jury make some inferences from that?
Well, if that had been the evidence, but respectfully, Justice Kennedy, it isn't the evidence, and I'm going to.
Okay.
I'm going to just move here.
Sure.
Katie Butler, just to clarify, the document to which you're referring is the original handwritten note by Larissa, undisputed by their own expert witness, in her own handwriting, the promissory note. They took the promissory note and they ran it through this electrostatic detection analysis thing that they do. And her testimony was that on page 820, I believe, that it did not indicate evidence of tracing. There was some imprints that suggested that there were documents that were on top of that promissory note that she may have been writing on, and then eventually she gets to that piece of paper, and it's like the old days when you were a kid and you would take a pencil and go over something. So it's that kind of thing. But again, it's inconclusive, and it's not really, doesn't even, that kind of evidence wouldn't come in a civil case.
Let me ask you this. Who gives a promissory note one day and then pays it the next day or within a short period thereafter? That's just it's just an extraordinarily improbable sequence. The timing on that for someone to give a promissory note and then to turn right around and write the checks.
Well, that's the thing about this case. There's more questions
So-
than answers. You have Larissa writing within 2 weeks before. She writes $7,000 worth of checks to another gentleman. We don't know why she's writing these checks and giving her money away. I mean, there's all manner of. And that's where I think where I'm at, and I actually still have some time. But is that what we're talking about here is
You're fine on your time. You've got
yeah, I see
about
that.
9 minutes left.
I
yeah.
know. I'm used to 10 minutes, aside. But you have to guess at how this happened, and we've never allowed juries to just guess by, well, gee, process of elimination. We don't have any forensic evidence.
Ms. Lerner,
And
let's
if we
Ms.
look-
Lerner, let's pause there, because I agree with you that you have to speculate about how she was killed, all the circumstances surrounding that. But we've already established that there was sufficient evidence that a jury could determine that she was dead, and there's no requirement that the state prove how someone did the crime. The only question is who, correct?
Well, who did it?
Yeah.
Yes, and in
So that speculation about how maybe he tortured her or put a gun to her head and had her write the checks and write the promissory note and do all that, I mean, that would be all speculation, but don't you have to speculate more to suggest that it was anybody else other than him? Isn't that a speculative doubt?
I think that it's certainly a reasonable doubt that we have to entertain. But even so, if you look at the missing person cases that are out there, and the ones that they don't cite a single one that is even remotely like this, and that's because they're not brought when there's no substantial evidence, and they shouldn't be. I mean, in the missing person cases that they do cite, Myers, confession, corroborating injuries. Even Crane, it's a small child who goes missing, and the child's DNA is found on the defendant's boxer shorts, and you've got gouge marks that he has from the fingernails of a small child. The Virginia missing persons case, there was a dog scent evidence tracked from the crime scene to the defendant's front door, and in Bush, there was just no guesswork there, because the jury knew that Bush was responsible. There was the solid evidence of criminal agency. The DNA is on the murder weapon, and his 5 bloody footprints match. The 5 bloody footprints match his favorite boots. And I think that's really what we're talking about. What is it in our jurisprudence, where are we going to draw the line? Are we going to allow a verdict to stand on what really is speculation in this case, when their whole murder for money theory collapses under their own evidence that she did write these checks? This is what she did. This was not out of character. We don't know why she gives money to other men, but she does, and she has. I think it's reasonable to infer that she has plenty of it beyond what she had in those bank accounts. And so we understand that this is, and the 3rd District said the same thing, awfully suspicious. But suspicion alone has never been enough to convict. And we're asking this court to affirm the 3rd District. If the court has any other questions, I'm happy to entertain them. Thank you for your time and attention.
Thank you, counsel. Rebuttal.
This court has reviewed the facts of this case at length, but just briefly, to touch on a couple of things Justice Lawson discussed. As far as these checks, these 2 checks in this promissory note, the jury didn't just hear this 2 lines of testimony from the FDLE examiner. We know that the FDLE examiner qualified her opinion as to the 2 checks. She said it's probably written by the victim, but I'm looking at machine copies of these checks, so there's some qualification there. As for the promissory note, as Chief Justice Kennedy pointed out, it was written the day before it was that respondent received the sum of the entire promissory note. It's completely unheard of for someone to write a promissory note for $20,000 and then the next day repay it. And there's significant other factors that come into play, pieces of evidence that show that, there is something nefarious going on with these transfers of money. We know that there's no way possible for the respondent to have funded this amount. The state introduced bank statements from the past 4 or 5 years, and there was no significant deposits other than annual tax refunds. We know that there was no withdrawals from his amount matching the sum that he purportedly lent to the victim. We know from the interaction with his wife at the police station that there's just no way he could have funded this amount. There's no evidence that he was going to open up some sort of business or anything like that with the victim. There was just everything else refuted that. All the other evidence that the state adduced refuted that. So we don't just look at the FDLE examiner's 2 lines of testimony in isolation. The jury did not just hear that. Perhaps if they did, then maybe there would be some legitimacy to these transactions, but they heard a plethora of evidence that indicated there is no legitimate reason, no valid reason for a respondent to receive these funds. And I think the state established that pretty sufficiently. As far as the car, roughly a month after it was sitting in the sun, it still smelled of cleaning agents. That's the extent that it had been detailed and cleaned. There's only one person present who was found in that car. It was respondent. We know that he was seen driving the car the day after the victim disappeared, withdrawing money from her ATM account. And we know when he did that again a week later, the car had already been dropped off. In the footage from the second ATM transaction, he's not in the car because it's already been dropped off. He's seen standing alone. There's the only speculation that would occur here is if someone else was responsible for the victim's death in this case. There is no one else responsible. And I think what the third did is get into reweighing this evidence, which we know that reviewing courts do not do. It's not within the province of a reviewing court when making determinations of the legal sufficiency of evidence needed to sustain convictions. Applying, even under the old standard, the state submits that the evidence is sufficient, but under the applicable standard now, it certainly was. So we would ask this court to reverse, if there's no further questions from this court, we'd ask that they quash the decision below and reinstate respondent's convictions in the jury's verdict. Thank you.
Thank you both for your arguments in this case today. The court will now take up the next case on our docket, LULAC Florida Educational Fund versus Clark.
Good morning, and may it please the court. Bradley Marshall and Jordan Lukeman and Dominique Burkhart on behalf of the League of United Latin American Citizens of Florida. We'd like to request 8 minutes for rebuttal. This is an appeal of a final decision of the Florida Public Service Commission approving Duke's proposed Clean Energy Connection program to construct and rate base 10 solar power plants and to allow primarily large customers to receive bill credits for subscribing to the program. This decision is due to be reversed for 3 principal reasons. First, a designed windfall to a few select customers violates statutory requirements for fair rates with no undue preference. Second, the PSC's findings regarding benefits to the general body of ratepayers is not supported by competent and substantial evidence. And third, denial of cross-examination and discovery during the proceeding constitutes material error. On the first point, Duke has told a great story about this program. The participants pay more than the entire cost of the solar power plants being constructed. But when you look at the undisputed math...
I'm sorry, could you repeat that? I didn't understand. They ignored what?
That the participants pay the entire cost of the solar power plants being constructed. Okay. That's Duke's argument. But when you look at the undisputed math and take into account how much participants are being paid to participate in the program, it just isn't true. There is no fact question that the program at issue has been designed to award a net of almost $300 million in bill credits paid for by the general body of ratepayers.
I think this is important enough to walk through with us. So the way I understand the math is that you have to present value everything in order to determine what's paid for by who, correct?
Sure, we can present value it.
And so walk me through the math and why you say it.
Sure, if you look at
when you net present value everything, it's not completely paid for, and there isn't a extra money that goes to Duke's customers.
So if you just look at the present value math, and this is Hearing Exhibit 8, record page 2046. This has all the numbers of Duke's projections from the program that the commission accepted as part of their final order approving the program. And if you look at the present value, then there is no cost to the participants. They get all the benefits that the general body of ratepayers are receiving, plus an additional $67.6 million in present value. And so that is what we would say is the unfair, undue preference, is that they were receiving this benefit above and beyond what the general body of ratepayers is receiving.
Okay, so you're not saying that it doesn't benefit the ratepayers. You agree that it benefits, it's a net positive to the ratepayers.
Well, we would argue separately as a second argument that those benefit calculations is not supported by competent substantial evidence, but for the purposes of this argument, as to the legal question of whether it's an undue preference, we accept those facts as true.
Okay. And this is a publicly traded company, correct?
Yes.
So they get to do their business in a way that makes sense from a business standpoint, and then there's the regulatory end at the background where you determine if it's good for the ratepayers and good given all the considerations that the legislature has put out there, including solar and other things, that it's good for the state. So it's a two-step analysis.
Sure, I mean, I would agree with that. There is a two-step analysis. One is it good for the state, is part of the PSC's decision-making? Is it in the public interest? But there is a second requirement to comply with the statutory requirements of making sure there's no undue preference for any customer. And what we say is that when you have a program like this, that you're sending bill credits to specific customers that have a present value of $67.6 million, paid for by everyone else, that constitutes an undue preference and therefore violates the statutory requirements. And therefore the PSC erred in approving this program.
Okay. And
why have a subscription program at all?
I think what Duke would say is that there is a demand from their large customers to have a program like this where they can take credit for going solar and not have to install their own solar panels.
But couldn't Duke have their own solar program without a subscription program?
Yeah, in fact, Duke does have lots of utility scale solar outside of this program context where it's normal power plants. Everyone pays for it. Everyone gets the benefits of the plants. What separates this program is that everyone still pays for the solar power plants. They're still rate-based, but then you have specific bill credits paid for by everyone else going to the subscribers and participants in the program. And so they basically get to take, certain companies have sustainability goals.
I'm trying to figure out why. Why have the program? It seems like is there some kind of avoidance of some federal law by doing it this way? I know by doing the different installments of the solar panels at certain powers at different times, there's an avoidance of certain requirements for regulation purposes. Is there some similar requirement that they're avoiding in some way by doing it this way through a subscription problem or a program?
Not that I'm aware of, other than our argument that it violates the Power Plant Siting Act, which requires that generation of 75 megawatts or greater go through that process. But no, I think it's being driven by, and what the testimony showed below was that certain large customers have a goal of using clean energy, of getting their power from solar. And to install their own solar would be costly to them. And so this is a way it's a win-win in that those companies get to meet their sustainability goals.
Well,
They get paid to do so, and Duke gets to build more rate-based solar.
Okay, thank you.
Could I get your view on just clarifying from a standard of review and what it is exactly that we're reviewing? Because I understand that this sort of overall public interest standard for reviewing the settlement agreement, but then it seems like with kind of embedded within that, there's this issue of the fair, just, and not unduly preferential rates. And it seems like the way this has been argued, there's the part of the case that has to do with, is it overall kind of in the public interest to have more solar? And, there's the citations to the legislative policy and the fact that, customers want solar, et cetera, et cetera. But then it seems like really the problem, the big problem that you have, and that I think relates to this standard review question, is okay, fine, we all agree more solar is, if not kind of, unquestionably good, it's at least consistent with the public policy of the state and whatever. It would certainly not be our role as our court to kind of question that finding by the commission. But how you actually pay for it in this program in particular, what is it that we're supposed to be reviewing on the fair, just, and not unduly preferential rates?
And so what we would say is that taking all the facts that the commission found as true, that we still have these statutory requirements of making sure there's no undue preference, making sure that the rates are fair, just, and reasonable. And so since we've agreed, for the purposes of this argument on the facts, then the answer to that question of, is this credit program create an undue preference, must turn on the meaning of what is an undue preference and what is fair, what is just. And since those are statutory terms, according to Article 5, Section 21, this court may not defer to the PSC's interpretation of those terms. And so therefore it is a de novo standard of review, taking those facts as true.
Well, and what is, one of the questions, and this is really more for your colleagues on the other side, but it's not, obviously we have the factual findings about, projected, savings and all that. And I understand that that's disputed, but the standard of review on that is very kind of favorable to the other side. But it seems like these questions about what's fair and just and not unduly preferential, that seems like it's more of sort of a mixed kind of, it's a judgment, and I can't really tell from this order sort of what the, when you're saying that we don't have to defer to legal interpretations, I don't really know what the commission's interpretation of those terms is. All I see is just this kind of bald assertion that the rates are fair, just, and reasonable, and the observation about, the percentages of the benefits going to the, this, that, and whatever. But how are we, as the reviewing court, what are we supposed to be looking at to understand sort of the judgment that underlies that conclusion by the commission?
It is tough, given the final order of the analysis is quite short. But given that you see in the final order that adoption, implicit adoption of that finding that 87 point and change percent of benefits go to the general body of ratepayers, and therefore 12.7% don't, and that is from Duke's projections of the costs and benefits of the program, and that's from Hearing Exhibit 8. You can see where those numbers come from. And so in there is that, in present value terms, that payout of $67.6 million, that 12.7% going to a few select customers. And so given that basically the commission has implicitly adopted that fact, that 12.7% is going to the participants above and beyond their share of what they take as part of the general body of ratepayers, we would say that that's the undue preference that's unfair and unjust and unreasonable.
But I guess I don't really understand what, so, and again, this is really more for the other side, but from your understanding, so we know that from a present value perspective, the participation fees coming in are less than the bill credits. that are going to also be paid. So, but I mean, what sort of, I mean, I think just combing through the record, which frankly is kind of frustrating that the commission doesn't sort of explain sort of the rationale. But I saw some testimony that there's a benefit, having the participation fees gives a benefit because it, has money comes in and it allows the program to get off the road, to get started. And so maybe there's some sort of benefit that you have to kind of pay for by having the credits exceed that. But there's no sense of, how much. I mean, the benefits, the overall savings, and again, they're based on these, projections, assumptions, whatever, but the savings are big enough that you could have had the participation credits or the bill credits could have exceeded the money coming in by even more, and there would still be a net benefit maybe to the overall body of ratepayers. But we don't have any way of knowing like what is the proper sort of difference between what's coming in from the fees and what's going out from the credits, and how we're supposed to decide whether that's fair or not. I mean, so I just don't, I'm kind of at a loss for how we're supposed to evaluate that.
So there was a lot of testimony, especially on cross-examination, that the participation, the participant fees, the upfront ones, where they're in the first initial years are expected to exceed the credits by a little bit, do not meaningfully help pay for the program. It's less than 1% on any of the initial years. If you go to Hearing Exhibit 8, which is Record 2046, and look at the breakdown year by year in those first initial years where participants are on net expected to pay into the program, it's never even gets to 1% of the actual costs of the solar involved. And for that, they are then expected to receive, over the term of the program, almost $300 million, which is of present value, even taking into account those first few years where they're expected to pay more, is worth $67.6 million to the participants.
So now I'm a little confused. Is it your position that that is a sufficient basis upon which we can review this commission report as not demonstrating that the rates meet the standard of fair, just, and non-unduly preferential? Or is your position that there isn't a finding in the record for us to review that is sufficient?
It's the first, Your Honor, that there is sufficient findings here for a review. Although I admit it is, you have to search for it and take that 87.3% that's in the final order and see where that came from and what that had to have implicitly adopted for that finding to get there.
Counsel, you were.
Does the statute require that the commission make detailed findings?
No, there is no specific statutory requirement for detailed findings that I'm aware of.
And that's not unusual that a finder of, appellate courts review trial judges' decisions for abuse of discretion frequently, correct? And the trial judge isn't required in many instances to elaborate the thinking process. There's just a ruling, yes, no. So that's not unusual, right?
Especially not in when there is where there is a settlement for the commission. That
Right.
It's not unusual to see an order like this where they say,
Yeah.
we find it's in the public interest, it's fair, just, and reasonable, and not unduly preferential. But I think even given all that, you still have to look at, well, what is the underlying rates that they've approved here? And it's this tremendous value to the participants at the expense of the general body of ratepayers.
But, just to clarify that, though, so there's the findings of fact, and I know that we always, entities make findings of fact, and then we go through the record and make sure that, but when we're talking about something that's a judgment, is it your position that the APA doesn't require an agency to give reasons underlying that? I mean, my just basic sense is that one of the reasons why we have administrative agencies is to allow for reasoned decision making. And it seems to me that there's a difference between a court combing through the record to see if a factual finding is supported by evidence versus us being presented with just a bald, conclusory statement of a sort of a conclusion of a judgment, and then us having to sort of look through and just say the record and with no explanation of the reasons for it, and for us to sign off on that? I mean, isn't the whole point that they're supposed to give reasons for what they do?
I would say yes, Your Honor. The extent of which reasons they have to give, I would say is an open question. And I do agree, there's not much reasoning here, and I am going off of what reasoning they do have to say that based on that reasoning, that the result is an unfair preference and unduly discriminatory. I see that I've gone well into my rebuttal time.
We helped you, as is not unusual. You will have 6 minutes for rebuttal.
Thank you.
Good morning, Your Honors. May it please the court. I'm Adria Harper, representing the Florida Public Service Commission, and I'm going to address the questions that were raised by justices in response to counsel over here. First issue was the fairness. The second issue was the fairness of the program. The second issue raised by counsel that y'all had questions on was competent substantial evidence. The third had to do with the standard, so I'm going to try to go in that order to make sure I can address those issues for you. First, I would like to point out the fairness of the project, whether it was unduly discriminatory or not, was something that was addressed in depth in the evidence, and counsel is trying to ask this court to reweigh this evidence under 120.68, which I will talk more about in a second. The court does not have to do that. Those are factual findings by the commission that are supported by competent substantial evidence. The way the program was created to be a subscription-based program, there's evidence in the record about that too. Why it was done that way, how there was a demand for that from the customers, why it allowed for more cumulative savings to do it that way.
I'm sorry to interrupt you.
Sure.
It wasn't obvious to me. So again, the whole issue of why solar, why do we need more solar, that's fine. It's also clear from the record that there are certain of your customers who want solar for whether, these with the renewable energy certificates, I understand that they have either public commitments or legal obligations or whatever to use renewable energy, and they get a benefit out of that. And I understand, although it's certainly not clear from your order, and it takes a lot of effort to figure out how the program fees kind of help the program sort of get off the ground. But given, it seems like it's factually undisputed that in present value terms, the money coming in from the participation fees is less than the bill credits, right?
Correct.
Okay, hold on a second.
Okay. So
in a sense, and tell me, I'm a layman, I'm just trying to understand this, but there's a sense that somehow the overall body of ratepayers that the overall good is served by, in a sense, kind of paying the program participants for whatever the value is for the fact that they're paying in with these fees, right?
Correct.
Okay. And what I can't tell from this is how much of a payment is fair or just or whatever, because it seems like if the logic of it seems like the main justification is, look, we have this amount of savings, and if we have to pay this much to these participants to get these savings, then what is no skin off the ratepayers' back, right? But I mean, by that logic, you could have paid them, any amount that's kind of less than the savings would sort of be justified on that logic. And so I'm trying to understand why, how we're supposed to figure out what makes the decision to pay them, net present value, $60 million to participate in the program. Why is that fair? Would 30 million have been fair? Would 200 million have been fair? I mean, can you help me understand that?
Yes. Well, of course, the commission is going to look at the evidence that it's presented, and in this case, what they look at when it's a tariff is whether the general body of ratepayers are going to subsidize any kind of part of the program. In this case, the program was specifically structured, and this goes to one of the other questions: why did they do it this way and not as opposed to a base rate request or a as we call SOBRA, or a rate case. Well, it was designed in a way to actually give the general body of ratepayers more potential benefits by allowing the participating subscribers to cover the full cost of the program.
Okay, and so, and that's, and I really don't mean, this is going to sound obnoxious, but I don't mean it to be obnoxious. There's almost like an Orwellian sort of flavor to the way this is presented. I mean, when I'm paying, you know, just to make the numbers simple, if I'm paying $100 million in participation fees, and you're paying me, you know, $120 million in bill credits, how do you keep saying that they're paying for this whole thing?
Because they are paying for, this is not a rate, like going through the subscribers are paying for the solar plants in this case. They are paying for it. That's what the record shows. It may take them 7 years to pay for these plants, but within 7 years, they'll start receiving the credit to offset the payment. And that's what you don't get in another type of model where they're asking for just a rate, you know, rate increase.
But could you address could you address how the bill credit thing? I mean, it's like if I buy you a car, and I say I bought your $50,000 car, and then you hand me $70,000 back.
Well,
I mean,
their rate's
I don't
going to
understand
go
that.
up. Sorry to interrupt you. Sorry to interrupt you. The subscriber's rate goes up. I mean, a tariff
But
is a rate
everybody's
increase.
rates go up, right?
Well, not the low-income subscriber.
Okay, but I mean,
But not, I mean, actually, the subscribers' rates are the ones that are going to go up the most. And that's why there's a large portion of them are the bigger energy users. And that's why they are at risk, you know, that maybe later they don't enjoy as much savings. I mean, that's something that the commission looked at.
Right, and I'm sorry to interrupt you, but everybody is at risk. I mean, the difference between them and everybody else is that everybody else is equally at risk, but these guys get the participants get the bill credits. So if the general body of ratepayers, which by the way, my understanding of this is that the program participants benefit from the overall savings to the general body of ratepayers, and they get the bill credits. So, and all of the quote-unquote savings are based on these. And again, I understand in your business it's tough. You've got to make guesses about, you know, regulations and carbon taxes and whatever. It seems like most of the savings are based on things that haven't happened and that frankly involve like government action. So, and there are benefits from the program. You know, I think I saw something about people can put stickers in their window. There's this weird kind of, you know, these, you know, small group of people that have this unique interest in being able to say that we're using solar energy, and they get these very tangible kind of predictable benefits from it through the credits and through the RECs and everything. And then everybody else subsidizes it and might get savings, but there's no explanation here for how the commission decided that the amount of the subsidy was justified, as opposed to, I think if you just listen to Justice Plain, as a layman, you read this and you think, well, if this is such a great thing, why isn't the company just coming in and saying we want to build 10 solar plants and we'll pay for it like we pay for everything else? And you know, it's going to be a great thing because all of our general body of ratepayers are going to save X amount of money. I mean,
Well,
you know what I'm saying? Does that make sense?
I understand what you're saying, and I'd say first the record shows that the Duke would have not done this program had it not received requests to do a program like this from its customers. And second of all, the evidence does show that there's going to be savings and not a subsidy by the general body of ratepayers. And the reason why they did it this way is because, yes, there's a risk with the models and so forth, but there's less of a risk with the general ratepayer subsidizing what the subscribers are doing than any other kind of way that they could build a solar program.
And I don't really, that's honestly, I mean, and I've tried, I didn't find all that explanation. It's certainly not in the order. It's hard to find in the record. But let me just ask you, though, under the logic of this, the overall savings justifies this. It seems like as long as the bill credits are $1 less than the savings, that logic would justify any amount of bill credits. Am I wrong about that?
It's
I mean, I know
it's
you
hard
wouldn't
for me
do
to go
it.
outside the evidence because the evidence doesn't show that. The evidence shows that the program's going to be fully subscribed.
No,
most
but you're,
likely.
the commission decided that this was fair, right? That a $60 million difference between the bill credits and the participation fees, that's fair, right? Would a $100 million difference have been fair when there still would have been a net significant savings to everybody?
Well, I don't know. The commission would have to look at that.
Right, and you know why we can't answer the question? It's because we have no idea what your standard for fair is. You know, when he talks about a reasonable interpretation or whatever, there is zero reasoning in here. Like, I have no idea, and I'm not trying to be critical of you, but I have no idea as a judge how I'm supposed to decide whether this makes any sense.
Well, respectfully, to decide because I think the commission decided, and under 120.68, you have to not reweigh our factual findings.
And so whether something is fair is a fact.
Just, and
that's a
reasonable.
factual. That's totally
It's
a factual
supported
finding.
by a case-by-case basis, supported by the evidence. That's a 36606 finding that the commission makes, and that's done case by case and supported by the evidence. Now, there's also the public interest standard that was raised by counsel's briefs here too, which, you know, is relevant because this is a settlement, but we can't find something in the public interest and also find it to not be fair, just, and reasonable. So
let
really,
me ask you,
that's
just
it.
from a review perspective, just let me ask you quickly, the settlement thing, and your colleague on the other side didn't really emphasize this in argument, but it's a big part of their briefing. Given that there was a hearing anyway, and to the extent that we can call any of these things findings and whatever, there's, you know, we still have this. I mean, it's not obvious to me what difference the stipulation has made to sort of how this proceeded. And if there had been no stipulation, and if it had just proceeded on the petition and the commission had the same hearing and done an order, would we be reviewing different questions?
No, the commission
Okay.
would still have to
So
evaluate.
that's all a red herring, essentially. We would still be saying, is this,
A fair
is the,
justice.
are the rates, and then there'd still be this sense of, is the program,
Correct.
you know, in the public interest or whatever. And it
Correct.
doesn't seem like there's really any dispute that having more solar is in the public interest. It seems like the question is this weird sort of mechanism for paying for it, does that satisfy the fair, just, and reasonable rates without undue preference?
Correct.
Counsel, Justice Poston has questions.
Yeah, we talked about facts. I want to go through some facts. Did I understand correctly for you to say that the credits don't start getting paid until year 7 or after 7 years?
That's correct. That's what the projections are. a
Well, I'm looking
7-year
at the
payback.
schedule on appendix page 55 where it's list. It's a big schedule. It's a spreadsheet, and it shows the participant subscription fees and bill credits, and it shows credits start kicking in year 2022.
Well, that's because basically they want to ensure that the subscribers, just like any kind of other situation where there's a tariff or a rate increase, that the plant is actually in service before anybody starts receiving a benefit. But the testimony in the record also says that within 7 years, they should start receiving some kind of credit into the fuel clause because they're doing solar, so there's going to be some fuel savings. So there's a 7-year payback for subscribers, and then there's also going to be savings in the fuel clause for the general body of ratepayers. So I'm not
Counsel, I thought the way the record showed that the credits and the participation fees both start immediately. 7 years is where the amount of the credits actually exceeds the
yes,
value.
would they start getting a
And that's,
payback?
and that's what
Okay,
Justice
sorry, I
Paulson was asking.
misunderstood.
But the credits they start receiving credits in year 2022, right? There's not a delayed
Right, I think
a delayed
where I was
payment so that they're
Right.
getting more cash in that 7-year period to pay for the construction.
Right, and I think where they start receiving a benefit is in 7 years, where the credit actually starts to offset their additional rate that they're paying
Right,
as a
so
subscriber.
if you were comparing, let's say for that first 7 years, the net amount, the net from what they're paying for the subscription fee less the credit that they're getting back, the net amount, and if you were to compare that to what they would be normally paying by way of an electric bill without solar, is there some type of big cash influx coming in that's somehow paying for this construction in that first 7 years? What's that net difference for the first 7 years?
Well, I think in this case, there's no evidence of like a big cash influx that I know of. I mean, Duke can maybe address that.
So it's not
more
like they're
specifically.
paying, it's not like the subscribers are paying more in the first 7 years that would somehow pay for the construction of this to be an advantage to the whole rate base.
I'm not sure if the evidence squarely addresses that, so I don't know if I could answer that. I know what the cumulative,
Well, that's not a justification.
well, but what it shows is there's more savings with the program without it than without it. That was analyzed, and that's
That's
in the
looking
evidence.
for the whole 30-year period of time.
Correct.
So also, when you have the statement in there that the payments pay 104.9% of the cost, aren't you looking at the gross payments for the subscription fees coming in, not the net?
I believe so, yes.
Okay. The net amount is a net deficit to the program. It's not paying for the whole construction cost at all, right? When you look at the net,
Right. I know the 104.9% is to pay for the program,
it's a subscription fee
the subscription fees, yes.
without consideration of the credit.
Correct.
One last question. And the
Hope it's not more math, but yes.
well, it may be,
numbers.
but it's not. But it is related, and that is in the subscription agreement that I find in the record. It says that the subscriber can terminate their participation anytime.
Yes, that's correct.
Is that right?
That's correct.
So all the subscribers, if fuel costs go way down and it's more advantageous for them to be paying an electric bill as opposed to a subscription fee, they can say, I'm out.
That's correct.
And there's no penalty for that.
There's no penalty for that under the program, no.
Well, isn't this then just an absolutely free, cost-free hedge for energy costs by the people subscribing? It seems like a no-lose proposition. No wonder people were lining up to do this.
Yes, I agree. It is a way for them to hedge their bets, and it is also a way for the non-subscribers to get the benefit of solar energy, including low income.
So how is it advantageous to the rest of the rate base payers for the people who are receiving the subscription fees? They're going to receive ultimately over 30 years a net positive of $290 million. Isn't that absolutely on the back of all the other rate payers?
Well, in this case, again, I think the program was designed in a way to give the general body of ratepayers more of an opportunity and more of a chance to incur fuel savings that they wouldn't necessarily have with just a straight rate increase on everybody's bill, because in this case, there is a chance for the subscribers to fully pay for the plant and fully pay for the program, as opposed to everybody paying for it, whether they like it or not.
You keep saying that, but you keep ignoring the credit part of it. I mean, which is it's a certainty that's baked into this thing, unlike all the savings, which are, again, I'm not saying it doesn't meet a competent substantial evidence test or whatever, but it's based on all these sort of judgment calls about future, most of the savings is from government action.
Well, not all
right?
of the savings.
The
There's-
carbon tax and all that. I mean,
That's
that's
part
the,
of it.
that's the bulk of it.
There's generation savings as well. There's fuel savings. It's not all carbon savings. And this is something historically the commission has done, this cumulative value analysis and cost benefit, which is basically just a cost benefit
No, I mean,
analysis.
I'm not questioning. I understand that there was nothing that suggested that people were doing an unusual way of making those
But it
predictions.
is forecasting, and I don't think there's anything offensive about subscribers paying for plant and then eventually receiving a credit on their bill. I don't think there's anything offensive about that.
Well,
And I don't think that's unfair or unreasonable.
Well, if it seems odd to me that certain people who are able to subscribe and there are institutional subscribers who are in a better position to do this than residential, because residential may not be in the same house for 30 years or live in the same area for 30 years. So, but businesses and governmental entities are, so it makes more sense that they would benefit from this. But it does seem odd. If there was some benefit, I'm looking for some benefit that they're bringing to the table other than just what they're receiving as by way of benefit. I don't see what they're bringing to the table. I mean, you're telling me that they're bringing money, but they're receiving more money than they're giving out, and there's no commitment that they stay in the program. There's no risk to them. So I'm looking for some benefit that they're bringing.
Well, I understand, and respectfully, I would say the evidence shows that. The evidence shows that 87.3% of the general body of ratepayers are the ones that are receiving the benefit, and only 12% of the benefit is going to the subscribers, which is more than previous programs like the FPL Solar Together program that we've approved before at the commission.
Okay.
Is this one way to look at it for the industrial subscribers to the program who are getting the preference that arguably is that if a publicly traded company or anybody is going to invest in something, they're going to want a rate of return. And so they're saying, yes, we're going to give you the money now to pay for it. We are going to pay for it. The record shows that they are paying for it.
Yes.
But if we're your capital financing source, if we're going to pay for it, then there has to be a rate of return, and the credits are just the way to return the money to the investors in the project. Is that one way to look at it?
Yes, it's an incentive, yes.
Okay.
Correct.
And then the benefits that flow beyond that are what you just described to the general body of ratepayers who
Right.
get most of the benefits.
Right, because they're paying for the plant, and then the general body of ratepayers enjoy the savings and the fuel.
Right, and
terms
that
of
makes.
the-
Go ahead. I'm sorry.
In terms of the future possibility that this could act as a hedge if fuel prices globally tank or something like that, the projections and evidence in the record shows that it is going to be a benefit based on everything we know now, correct?
Correct.
Okay.
And that makes sense, but what I'm struggling with is understanding, it's, under that logic, Duke is paying these participants. There's some upside to getting the participation fees, right? There's some upside to it. And I just don't understand in the record, certainly not in the order, as to how the judgment was made that, we couldn't have gotten it if the net, right now the net is 60 million, right? If the net had been 30 million, would there have been no program? Because at the end of the day, the ratepayers are paying the participants
Right.
to whatever the upfront value of the participation fees is, and I have no way of knowing whether what's being paid is reasonable, rational, fair, whatever, right? Because again,
Well,
if the
I would
credits
disagree. I
had,
wouldn't
if
say
the
right.
credits
I think it's
had-
in the record.
if the- okay, tell me where.
Well, I think all the Duke witnesses and also the Walmart witness talk about how the subscribers are going to bear the brunt of the cost of the program, and that this cumulative present or net present value revenue requirements, the cost benefit analysis, is going to show that the ratepayers end up saving money in this model that they've used.
And if the credits had been
And that's what the
double,
order
if the credits,
references.
if the credits had been double what they are, and probably triple, quadruple, I don't know, you would still save. So, so is your position that if the savings to the general rate had been $500 million, it's 530 million, right? Are you saying that if the credits had been 500 million, that would have been a self-justifying